of this committee, which has been convened to consider the Cybercrime Bill 2017. We are very pleased to inform that this is being carried live on the Parliament channel, Channel 11, also on our radio waves at 105.5 FM, and can also be seen on the ParlView channel on the YouTube feed for members who are tuning in. This will no doubt be rebroadcast on a subsequent occasion. May I invite the members of the committee to please introduce themselves, and then we'll turn over to our first stakeholder intervention this morning, which is the Media Association of Trinidad and Tobago, whom we're very happy to have before us on a second occasion. May we begin with Member Huggins?
Good morning, everyone. Ronald Huggins, member.
Good morning, everyone. Wade Mark, member.
A very good morning, Fitzgerald Haynes, member.
Paula Gopi-Schoon, member. Good morning.
Good morning, Edmund Dillon, member.
Good morning, Paul Richards, member.
Good morning to members of the Media Association. Welcome to the Joint Select Committee. May I ask you to introduce yourselves for the public's benefit?
Sheila Rampasad, Chair of the MATT Steering Committee on Cybercrime and independent journalist.
Francesca Hawkins, member of the Cybercrime Bill Committee.
Khalifa Klein, member of the Cybercrime Bill Committee, Digital Coordinator at TT Newsday.
Rishi Muraj, CEO of Disclosure Today and consultant to the Media Association.
Good morning, Mr. Chair, members. I'm Dr. Crown, counsel to MATT.
Good morning, everyone. Joel Julian, the Vice President of the Media Association of Trinidad and Tobago.
And we recognize, for the benefit of the listening public, well-known faces in the media sitting in the public gallery. We welcome you to today's sitting. Some of you, it's been a while since we've seen you. I'd like to note for the record that this is the second occasion that we have the benefit and privilege and pleasure of having the members of the Media Association with us. In particular, we acknowledge receipt of your letter of May 9th, 2018 to the Secretariat of the Committee, also your letter of June 7th, 2017, and then further and very materially, today, your written submission from your consultant, Dr. Crown, together with supporting material representing what appears to be several hundred pages of submissions relative to this bill, of course disaggregated by supporting material, which I am sure will be immensely useful for us. Personally, I thank Matt for the commitment and dedication to analysis. Certainly the retention of your counsel and the submissions received have, I think, gone by far further than the 4 years of consultation that respective governments have had with you, and I wish to compliment you for that. I think it is an excellent move on your part that certainly assists us in the deliberations that this committee has to engage in, and I think that it was well worth the while to wait for this second opportunity. May I invite you to give your opening statement if you have one, and insofar as we have only just a couple seconds ago received your latest submission, which from a quick glance appears to be quite thorough, perhaps you can guide us through the headlights of those submissions, and we can have members interact on at least our first impressions of the submissions and any clarifications which we may wish to have from you. Please.
Good morning, Chair, and good morning to members of the committee, to our colleagues, our allies, and to viewers of the Parliament channel. Matt thanks the committee, of course, for acceding to our request for a second appearance to continue dialogue with you on this bill. Just before I begin, please allow us to welcome observers to these proceedings. We have in the public gallery Ms. Dawn Thomas, CEO of One Caribbean Media, parent company of the Trinidad Express, TV6 and I-95.5 FM. We also have Ms. Judy Raymond, Editor-in-Chief of the TNT Newsday, and we have as well some representatives from Reuters, representatives from the Institute of War and Peace Reporting, and we have some of our colleagues here from Cuba as well. The Cybercrime Bill 2017 signals in its preamble its intention to interfere with citizens' freedom of expression and freedom of the press. Both are rights guaranteed in the Constitution. The onus is on those seeking to interfere with a pillar that is holding up the nation house to make an incontrovertible case why they must do so. MATT, having been involved in this process since 2014, excuse me, and having consulted with many previous administrations on related matters, is not persuaded that the case has been made. The remedy we submit is a public interest exemption to protect all individuals and organizations working towards greater transparency in public affairs. This bill seeks entry into a patchwork legislative environment that is already untidy. A potent illustration of that is that today, 4 days after the European Union implemented their General Data Protection Regulations, commonly known as GDPR, private data of citizens in Trinidad and Tobago remain open to use and misuse with no established standards of protection. Information on citizens digitally stored in restaurants and fast food outlets like KFC, at TAP, at public and private hospitals, on eGovTT sites. Information like citizens' medical prescriptions, their ailments, their allergies, their next of kin, their contact numbers, home addresses, and directions about how to get there is not protected. Journalism is still vulnerable to criminal liability for defamation and libel under Section 8 of the Libel and Defamation Act. This law is 167 years old. Section 9 was repealed in 2013, but Section 8 remains in force. Widely divergent interpretations threaten to neutralize the best intentions of the Freedom of Information Act. And of course, whistleblower protection is still not yet a reality. Given this environment, MATT agrees with the Computer Society that this bill is best featured in a package of legislation consistent with a widely consulted policy on cybersecurity. Research by our team uncovered reference to a national cybercrime policy that was approved by Cabinet in February 2013. The policy itself, however, could not be located. Cybersecurity legislation should balance criminalization of citizens with protection of citizens' data, and further should encourage all those digital activities that enhance democracy in unprecedented ways. This is a brave new world. Navigating it requires clarity, thoughtfulness, and nuance towards a coherent, multi-pronged cybersecurity enactment. MATT has repeatedly explained how severely the public interest is injured in this bill. The association has conducted diligent research and paid studious attention to the proposed legislation and submits to the JSC today this document to further, and we hope definitively, assist with the committee's understanding of the undemocratic implications of this bill. Our remedies are also detailed therein. MATT recognizes, however, that the digital space can be used by criminal enterprises for egregious wrong, small and large, and we know legislators have within their grasp an opportunity to dissuade abuse through punishment. So should legislators proceed with this bill, MATT would like to point to the following. 1, this bill creates criminal offenses added to the civil remedies already in place. A building cannot be arrested, charged, and jailed, nor can a publication or a broadcast. People are arrested, charged, and jailed. The consequence of this bill in its present form will put in jail, journalists and other individuals and organizations who function in the public interest to expose to the public evidence of corruption and other wrongdoing. These include organizations like Disclosure Today, Fixing TNT, trade unions, and individuals, for example, like Afra Raymond. MATT must ask why legislators wish to jail those of us who expose wrongdoing. I have looked at stories by many of our members, and most of us, including me, would fall afoul of the bill as it is currently written. Why do legislators wish to jail me and my colleagues? This bill demands that journalists, whistleblowers, and civic-minded citizens and organizations see evidence of wrongdoing and walk past it because we are not authorized to take it or to copy it. To take that information and to inform the public about it is to risk significant jail time. 3, the more MATT looks at this bill, the more problems we identify with it. In that regard, in addition to the clauses we have already red flagged, clauses 8, 12, and 18, MATT now red flags clauses 5, 7, and 11. 4, this bill cynically labels as hackers and thieves the press as an institution, journalists engaged in the work of that institution, and those individuals and organizations working towards transparency in public affairs. The circuitry of this bill we submit is faulty. Journalism is not hacking, nor is it thievery. Disclosures about wrongdoing by individuals and organizations are not hacking or thievery. This bill pulls journalists and others working in the public interest inside its fold and then criminalizes us. This is the antithesis we submit of democracy and this country's presumptive commitment to freedom of the press. Finally, at a meeting between MATT representatives and the Attorney General's office on December 16, 2016, MATT proposed a public interest exemption that would protect journalism, Calypsonians, artists, writers, researchers, civic-spirited citizens, and organizations working towards greater transparency in public affairs. At that time, the Attorney General's office rejected our proposal. Today, MATT reiterates that original proposal. A public interest exemption across this bill would retain criminal accountability for mischief and malice, while preemptively protecting the constitutional rights of all citizens, organizations, and institutions engaged in nation building through greater transparency. Our team is prepared to engage with the committee on these and related matters, and we thank you again for the opportunity.
Thank you, Madam Chair, for your passionate advocacy on your cause. May I just ask for the record where the Attorney General's office refused the submission for a public interest argument?
AG, at a meeting that the Media Association had, a consultation meeting at the Attorney General's office, held at the Attorney General's office on December 16, 2016, MATT proposed then a public interest exemption, and the response from the Attorney General's office at the time was that that was too broad an exemption.
Well, that's materially different from saying we rejected out of hand. And in fact, your written submissions demonstrate otherwise. Because in treating with the concept of finding a form of formula akin to Reynolds' principle, but not exactly the same, because obviously the civil law does not apply to the criminal context, your submissions say that you would look at it in a particular way. So I'd like to just correct the record. We did not agree in the consultative process to blanket exemption. We asked for consideration, and we asked MATT, in fact, to consider a formulation of a type suitably organized after consultation with your attorneys for a type of exception. So I'd just like to state from my perspective, having been a participant in that meeting and recalling very well at least what was said from me, that I don't accept your submission that we blanketly rejected a submission. I find support in your reference to the material on the Reynolds exception and your very helpful disaggregation of that issue in the form that your counsel has presented. So I just wanted, at least from my part of the equation, to correct that from my point of view. May I ask a few questions, please? And perhaps start off with, do you think it best and useful that we descend immediately into your submissions? Because I've had a chance to have a look at them while you were presenting, and they are indeed quite intriguing and very useful. I note that they treat with a number of positions quite clearly put out in this summary that your counsel has reduced for us. A lot of them also revolve around the acceptability of the type of exemptions which we are collectively trying to find for the journalistic purpose. So this committee has on all occasions, and in fact in your first appearance before us, invited your further submissions on the type of exemptions that the media thinks this committee should consider. And we're very grateful that you have, in fact, come back with those exemptions. Is it your view that we should jump directly into your council's submissions and then perhaps reserve our questions to the end?
AG, your comment, read the public interest exemption at our meeting of December 16th, 2016 at the AG's office is noted, and MATT retains its recollection of what occurred at that meeting. In terms of what we have submitted to the committee about a broad public interest exemption across the bill, MATT is prepared to add to in either format. Whether the committee wishes to ask questions, we are willing to take that, and if you're willing to drill down at this point, we are also willing to do that. So that will be left to the committee, through you, Chair.
Appreciated. I think it perhaps best as we have your counsel and we schedule this meeting around his availability, that we do invite your counsel to give submissions. Thank you for noting our respective views on an issue which we clearly agree to disagree upon. May I invite your counsel to assist us with his submissions?
Thank you, Mr. Chair. I think an overriding theme of the submissions is the need for a public interest exception in the Act. And the exemption is not limited to journalists. It is not a journalist exception. It is not a task of defining what is a journalist, which is an impossible task. It is an exemption that is intended to further anyone who operates in the public interest.
So shall we call them the whistleblower exemption?
No, I would not use such a value-laden term.
Could you characterize it for us then?
I would characterize anyone that operates responsibly, receives information, reviews it, operates responsibly in the public interest, should benefit from this exemption.
So more than just the passage on of what you receive, an active consideration of what you have received?
Not necessarily, Chair, if you'd allow me to complete the thought.
Sure.
So what the exemption seeks to do is it seeks to protect people that operate on information they receive in the public interest. And so that is in part the media, but it is in part, I assume what you'll hear from UTT later, is academics also routinely receive information. And the way the bill is written, academics themselves are now cyber criminals. And as I wear two hats as both counsel and as an academic, quite frankly, I share Dr. Ramprasad's view that I don't view myself as a cyber criminal when I receive information and I write papers in the public interest. There are also trade union membership. Trade unions have traditionally been formed from surreptitiously obtained data. Without an exemption for matters of public interest, trade unionism is directly impacted by this.
Sorry, Dr. Crown, I'm just trying to get from you. I had asked a question, and forgive me for interrupting, as to whether you were drawing a distinction between the mere passage of what you got, i.e. relaying it, I'm selling it as I bought it, versus I've considered it. And you told me that that was not it. So I'm trying to get what the mind of the receiver for this public interest exemption is in your submission. Is that somebody that actively considers, seeks a comment, then publishes in the public interest, or is it someone who just republishes something which they have gotten? I'm looking to the subjective analysis of the individual from a mens rea perspective in the law.
Correct. Okay, so Chair, in relation to that, it is not simply somebody who reviews information and necessarily edits it, reviews it, acts on it. It could be somebody that just receives information, or it could be somebody that just conveys something. It doesn't necessarily have to be the acting on the information or the editorializing of it. So with respect to MATT, what I think is missing in the equation is understanding that journalism is not the reading of news. That is the tip of the journalism iceberg. The rest of journalism is lost on the public generally, because we don't see it. But the journalistic process, journalism with a capital J, that is impacted when we do not permit surreptitious disclosures of data, where in fact in a very formal sense, the legislation is written as to not impact journalism, as to not impact academia. But substantively, that is exactly what it does. And in the bundle of documents you have, there are very real examples from Nigeria and from even this committee apparently relied on the Philippines partly in drafting its act. The Philippines itself has experienced massive censorship of the media in relation to their act. So that is what we're talking, the substantive effect of not permitting the media to do their job, or the media and others, but primarily Matt's concern today is obviously the media, but it is much wider than a journalistic exception.
Sure. Please continue.
So, Mr. Chair, we have proposed language for a public interest exception, and you will appreciate, Mr. Chair, as I'm sure others would be, that it's drafted as an exception being that it prima facie, so from the start, it excludes the conduct from criminality. Because what has transpired in previous meetings of this committee is there's been, in my respectful view, an undue reliance on that phrase, without lawful excuse or justification, that's laden throughout the act. That phrase only comes into play after you've been hauled into jail. It is only an affirmative defense one raises after you've been charged and then after the media fraternity start self-censoring themselves. We have proposed an exception that excludes the conduct from criminality from the start, much like a fair dealing exception, as I'm sure.
Forgive me for interrupting. Perhaps you could just assist in clarifying this. Wouldn't an exception be called upon by way of answer to a charge?
Correct. So the exception.
What's the difference between the lawful excuse in arrears argument and the I'm in the exception argument? Don't they both come in arrears?
Correct. So they both come into play. So the exception argument, you can raise the exception naturally at trial, but the exception argument also comes into play as to whether you are deciding as to whether to charge someone or proceed with the criminal sanction.
Would you distinguish that from the lawful excuse argument?
Well, the lawful excuse argument, so as the committee is well aware, throughout the act, throughout the clauses that Matt has identified, there is this phrase, if the conduct is essentially done without lawful excuse or justification, then it becomes a crime. The problem is...
But doesn't that also fall in with the whether a DPP should direct upon a charge? You see, what I'm trying to understand, and forgive me for interrupting, but I just want to get it clear. Your first submission was, let's give the exception up front because there is a danger of a charge being offered and somebody being subjected to having to raise a defense. Right. I'm trying to understand how that applies to your submission, that if I give an exception up front, one is not subjected to having to offer the exception in arrears or as a defense. I'm trying to understand the upfront versus arrears argument.
Understood, Mr. Chair. So the exemption argument operates on both levels. So it operates preemptively and it operates at the level at the trial. So the analogy...
Thank you.
No, Mr. Chair, again, if you'd allow me to finish my thought without cutting me off. In the copyright context, there's a fair dealing exemption. The fair dealing exemption deals with copyright matters that ordinarily would amount to a copyright infringement, but it is prima facie excluded from liability. So people don't pursue, people get opinions and so on and do not pursue a claim based on that exemption. But it also can be raised as an affirmative defense at trial. So it is exactly the same type of situation, the same type of analogy we're proposing with respect to this defense.
May I ask you for your view on if the committee were to consider the introduction of a safeguard, for instance, and this is to bring to life your two-endedness of the equation, because lawful excuse and exemptions both fall into defense categorization, but also whether charges should be laid categorization. Would it help if the committee were to consider the Director of Public Prosecutions being the sole person to initiate action for these types of matters?
So, sorry, Mr. Chair, could you explain as to why
So I'm in following your submission, which I think is very useful. You're saying, let's go for exemption, because exemption qualifies on two ends of the spectrum. Yeah. One, whether a charge ought to be laid at all, that is prior to charge. And secondly, by way of defense, where somebody says, look, I'm subject to the defense position because I'm exempted. Respectfully, lawful excuse and justification has the same formula. But the filtration, I think, is a good mischief. Would a police officer who's charging have the skill to exempt or apply the exemption? So I'm asking, the formula that is used in law quite frequently is where you put the caveat that it is only the Director of Public Prosecutions who can direct the laying of a charge for a matter of this type, so that there is a greater remedy available in the lawful excuse or exemption argument in not having the charge laid at all, because one assumes that the DPP, in his constitutional independence, would consider that there is no merit for laying the charge.
One sec, sorry, Mr. Chair.
Mr. Chair, it might be helpful to the committee if we talk a little bit about the public interest as a concept, conceptually, that we want in the exemption. And perhaps I'll ask Ms. Hawkins to do that, and perhaps after that, if through you, Chair, if the committee can perhaps consider an answer to why all of those suggestions as opposed to the public interest exemption. In other words, what is problematic about a public interest exemption?
Oh, no, sorry. Perhaps
Perhaps
I've derailed this. Let me state, at least this is just one individual's view as a member of this committee. I think that your acceptance that we find a formula for public interest exemption, which is something that I have repeatedly recommended that you do, I think that that's an excellent one. I'm very intrigued personally by the submissions of your counsel. I interrupted him before getting to the public interest exemption, to look whether filters should be put in before, because he raised a very important issue, which is exemption upfront versus defense. Because it can be argued that it's very onerous for someone to have to engage in a criminal trial, be brought before a court, answer a charge, and then offer a defense. So I was intrigued by that particular argument, and I immediately, and I apologize for interrupting the flow, but it was important to catch his argument, wondered whether a filtration of DPP. Let me make it abundantly clear. I very much want to hear, personally, as a member of the committee, the expansion of the idea of this type of public interest argument. And your counsel, I think, has given us some very good thought from what I've seen here. So may I respectfully ask that he continue with his submission? Because I want to get to that from his legal perspective first.
Okay, we'll ask Dr. Krong to continue, and then perhaps Ms. Hawkins can make a submission as well. And I think the idea in the Data Protection Act of the Information Commissioner may be an idea to introduce at this stage in the context of what you're saying with respect to the DPP, Mr. Chair.
Thank you so much.
Mr. Chair, so in relation to the DPP's office serving as another level of protection, then that, in fairness, can work. But that is more the practical implementation of the Act than itself the wording of the Act. And what we're trying to get across is, and I know you made the comment that that phrase, without lawful excuse or justification and public interest defense, might mean the same thing?
No, not necessarily. The application of it as a blocked charge and a defense are the same.
Okay, fair enough. Because I do want to raise the point that in previous meetings, that phrase has been used to perhaps suggest that things like journalism could fall under the ambit of that phrase. But I would suggest that that is not, in fact, true at all. Without lawful excuse is, in fact, an excuse sanctioned by law. Well, and in the absence of that, and again, without lawful excuse or justification, and justification, again, is an after-the-fact type of thing.
I accept your argument that one would have to wait on judicial interpretation to solidify the journalistic exemption as a lawful excuse, because it may very well filter through a constitutional perspective. But I don't, for one moment, suggest that Parliament should not, quote-unquote, in its wisdom, condescend to exceptions that are being thought about here. So I'm intrigued to get to the thoughts that you have in the language for the public's interest exemption and the rationale behind it.
Right. Well, fair enough, Mr. Chair. I mean, at the risk of preempting what a court might say, the explanatory notes to the Budapest Convention on Cybercrime, which is the most widely adopted convention on cybercrime, as the committee may well be aware, there's 57 signatories, and that convention is roughly 2 decades old. that convention actually has an explanatory note, an explanatory report to it, and it does go into detail as to what may in fact constitute access without right. And I draw the committee's attention to, in the explanatory report, we have it in the big bundle at tab 4. It is explanatory note number 38. It is a very detailed paragraph. I won't read it in the interest of time, but that explanatory note, it occupies 1/3 of the entire page. Nowhere there is journalism or freedom of the press or academia mentioned. Nowhere. When Europe turned its mind to what that may include, it specifically said acts to maintain public order, protect national security, investigations, and so on. So if someone were to allege that that phrase, without lawful excuse or justification, can cover journalism, one can simply point to the most authoritative text on cybercrime in the world and indicate that even in Europe, which is extremely concerned with freedom of the press, protections of privacy, human rights, there is no mention of that whatsoever in that explanatory report.
Well, I do accept your argument, but we don't deal with the European Convention or in its forms or fashions here, so I accept that there are differences. Otherwise, MAPA versus the UK would be a very stark difference from what we're doing here on a different end. But let me not interrupt your flow. We could, as lawyers, come with different perspectives. Can you dive to what you consider your public interest argument should look like and the rationale and how we attach the mens rea and actus reus elements to it?
Well, so, Mr. Chair, in the previous meeting with Matt, you had raised Reynolds. And so perhaps for my clarification, I would just like to know the context in which you had raised Reynolds. Because in fairness to members of the committee, they may not have been able to understand it legally from what you may have been asking. So I would just like to know.
Thank you very much, Dr. Crown. In treating with Matt's engagement, which I thank them for, again, profusely, it was recognized, this is before we got to committee stage, at Attorney General's office in coming up with a bill stage, that there's a very viable argument and a need for a journalistic exemption. The fourth pillar of our democracy must be preserved. Where one finds the balance is really the problem. What is a journalist? What is public interest, etc.? Matt had appeared without counsel, and obviously, I can't advise Matt. I'm there to receive their consultation. So I recommended to Matt that they retain counsel, specifically to consider the language that Matt would be appropriately satisfied with as a suitable exemption. I asked them to think about the civil side of how Reynolds works, where there's been some civil, albeit in defamatory context, consideration of how public interest ought to be applied, what the fairness in the matrix is, seeking comment from those who were affected, etc. It wasn't that one should accept Reynolds and transplant it from the civil law to the criminal law. That would be obtuse. It was to think of a formula that Matt would be happy with in making its advocacy, because I think we had gotten to the point where we agreed that hacking and cyberbullying and criminality ought to be dealt with, but we agreed that the penumbra could be so dangerously large that journalism could potentially be stymied. Matt made a very useful submission that whistleblowing legislation ought to accompany this. There is, in fact, on the Parliament table right now a whistleblowing bill. And Matt also observed something which I agreed with, that our data protection laws needed to be looked at from a constitutional perspective. So there were 3 work products on it. We've been urging Matt for quite some time to retain counsel, to help us from a legal perspective, and quite helpfully, you have arrived, and your submissions are very welcomed. So it was in that context that Reynolds came up as a point of reference to work towards the criminal perspective, because obviously you can't just take Reynolds and apply it to the criminal context. So it was in that arrangement.
Okay, thank you, Mr. Chair. So with Reynolds in mind, we did come up with what we believe to be a public interest exception that can apply across the board to not only journalists, but like we say, to other people, Calypsonians, trade unions, and so on, academics, researchers, and so on. So I will read for the record the defense that we have come up with, and we propose what in fact could be statutory language. So we propose it in a way that if you wanted to copy and paste it, you're welcome to.
I think Minister Hines was jumping in, not on the copywriting of the language, but he was jumping in on exemption versus defense.
No, there's no breach of the Copyright Act anyway.
Yeah.
If we did that, so it is. So we do propose a public interest exception, and I guess it would fall under. It would be a new section under the Act, perhaps Section 42 or something. And the language we propose is that nothing in this Act shall criminalize, or is intended to criminalize, acts or omissions done responsibly and in the public interest. So there are two limbs. It has to be an act done responsibly. It has to be an act done in the public interest. And what helped inform why that test, because there's a joke in law that all tests should be threefold. So why is the twofold test? It comes in part because of a Supreme Court Canada case called Grant and Toaster. And Supreme Court of Canada, in that case, they expressly said that Reynolds was too narrow of a defense for the media. They said that the Reynolds is an extension of qualified privilege. Qualified privilege is not concerned with freedom of expression. Qualified privilege as a defense is concerned with the occasion of the privilege, job references and background checks and so on. And so the Supreme Court of Canada came up with a test called the defense of responsible communication on matters of public interest. And so that is a brand new test in civil defamation law that intended to cover anyone that deals with matters, publishes something in the public interest. So not media houses, and so on. And the Supreme Court of Canada, in that case, said there were two elements. It has to, again, be something that is done in the public's interest, and they explain what qualifies or what may not qualify as the public interest. And it has to be done responsibly. And the responsible part is essentially the Reynolds factors, but as you probably know, Chair, developments since Reynolds and Jamil and so on have emphasized that the 10 elements of Reynolds factors are in fact not 10. They could be 0 or they could be 20. It's whatever in fact is relevant to the court in determining
much
the
like proportionality. May I ask this question? Have you come across any formula which is a little bit more prescriptive as it relates to the second limb, which is the public interest limb?
Well, the public interest limb is informed through case law. Public interest limb, what qualifies as public is informed through the case law, and quite appropriately, I guess, the government on its Freedom of Information site has an entire page dedicated to what qualifies as the public interest. It's foi.gov.tt/no/10. I mean, that is the exact page set out to define what is in the public interest. So I don't think it is a tough task to figure out what may qualify as a public interest or not under the Act.
I wasn't suggesting that one couldn't find assistance on what public interest is, be it in judicial review, be it in defamation, be it in whatever spectrum. I was asking specifically whether in any of the formulae of text, of wordsmithing of legislation, you've come across something which prescriptively deals with it. I'll take your submission to mean that you prefer to leave it at this level and allow the courts the latitude to move with the public interest argument as it evolves from time to time, correct?
Yes, Mr. Chair.
May I ask this question?
Sorry, Mr. Chair, but it's not just a yes, but it's a yes because the public, what is in the public interest varies with time. And it cannot be, it is almost an impossible task to define the public interest. That does in fact vary.
We are on the same interest, which is why I use the phrase from time to time. So we are exactly on the same page. May I ask this question? What about the perspectives on a reversal of burden?
What about it, Chair? No, specifically, I'm not sure of the question.
So in fulminating upon an exemption, have you come across anything that you've considered where the burden ought to be upon the defense to prove its case?
The burden is on the defense to prove something is responsible or in the public interest?
Yes. So under our Constitution, we're permitted to reverse the burden. When the reversal of burden applies to a defendant, it falls to a balance of probabilities, and once satisfied, it shifts to the prosecution on a proof beyond reasonable doubt basis. So I'm wondering, in your expert field, because you are one of the unique experts in this field, have you come across any formula which treats with a reversal of burden of that type?
Not in relation to this, no.
Okay, thank you. Forgive me, please continue.
Thank you, Mr. Chair. So it was from Grant and Toaster that we proposed that test of acts done responsibly and in the public interest. Acts or omissions. It could be an omission done responsibly, interestingly enough. So so that's the conclusion of the opinion, but everything before that simply highlights all of the provisions that are triggered by not having an overriding public interest exception.
So that would apply then to the observations for the other clauses, 5, 7, 11. Does that sort of feed into that matrix?
Agreed. 5, 6, 7, 11, everything.
Thank you so much. And again, Dr. Crown, thank you for allowing me to interrupt you to catch ideas in between your submissions. I know it isn't the most constructive way at times to have somebody interjecting into your thought train.
Well, that's fine. As long as it's not considered a data interference, we're fine.
May I ask members of the committee, please, to join in?
Thank you very much, Mr. Chairman. Before I pose my questions, may I put on the record that I am just like all of us here, members of a committee. I'm a member of the opposition on this joint select committee. And I want to disabuse from the mind of Mrs. Sheila Rampasa that it is anywhere close to my intention to be a participant in any activity that may result in the incarceration of you as a journalist or my colleagues who are trade unionists and others. So I just thought I should put that onto the record very early. But may I also ask, through the chairman, Mrs. Rampasad of the steering committee, the following. I observed that in the submission you made earlier, reference was made to certain specific clauses in the legislation. I think you refer to clause 8 and clause 12, if I recall distinctly. But you also made reference to clauses 5, 7, and 8. But in a document that was submitted to this committee and headed Center for Law and Democracy, dated the 1st of June, 2017, at that material time, the MATT also highlighted clauses 6, 9, 12, 13, and 15 as areas of concern to MATT. I just wanted to get clarification as to whether those clauses that you had highlighted in this document, which was attached to your letter dated June the 7th, 2017, still hold, or whether, for instance, the latest submission by Dr. Crown has superseded those particular matters. I'm just seeking clarification.
Thank you, Member Mark, and through you, Chair, thank you so much, Member, for your comfort in keeping me out of prison. I do appreciate that, and it is well taken. Our latest updated position, as it were, for clarity, would be these clauses. Clauses 8, 12, 18, 5, 6, 7, and 11.
All right, thank you so very much. And may I also inquire from you, based again on your introductory remarks, whether it is MATT's view that this committee ought to consider the full proclamation into into law rather, of the Data Protection Act of Trinidad and Tobago. As you're well aware, only some sections of that act have been proclaimed, and several others have not yet been proclaimed. In light of your submission, in the context of this cybercrime bill, is MATT submitting to this committee that consideration ought to be given by this committee as it relates to the full proclamation of that Data Protection Act?
Thank you, Member. And through you, Mr. Chair, the Data Protection Act, in fact, from our research, the bits that have been proclaimed are those bits only pertaining to the Information Commissioner. So it has been very sort of narrow in the proclamation areas. But I will pass you on, Member Mark, if you will allow me, to Mr. Maraj, who is our point person, as it were, on data protection.
Hi, good morning, members of the committee. To answer your question, Member Mark, and to put on the record also, my history with data protection legislation is that when it was initially passed in 2011, I at the time was the Senior Freedom of Information Officer attached to the Office of the Prime Minister, and we dealt with the data protection legislation at that time. I think I would have met with the Honorable Chair at a joint select committee when we were considering the bill at that time, when the bill was proposed and the bill was passed. Subsequent to that, up until now, my recommendation would be that I think while it is important that proper data protection legislation be put on the books, data protection and the whole idea of privacy and the rights under privacy have expanded beyond 2011 to now. As Chairman Rampersad would have mentioned earlier, just on the 25th of May, the European Union implemented the General Data Protection Privacy Regulations, and that has one of the more superseding legislations right now internationally with regards to data protection. And I think seriously, given some of the issues with our data protection legislation as it deals with the media, and the way it treats with the media and personal information, that our data protection law needs to be probably revised in order to ensure that we capture it perfectly with regards to how we treat with people's information and also how we treat with organizations that collect and disseminate people's personal information, as well as the way the media, NGOs, trade unions, and other civil society organizations would work with regards to data protection.
Yeah. May I also ask through the chairman, this public interest provision that Dr. Krong mentioned, are you saying, Dr. Krong, if I may, through the chair, are you saying that if this provision is enshrined or entrenched in the proposed legislation, your argument as it relates to those clauses outlined by Mrs. Sheila Rampersad would become null and void and of no value at the end of the process? Or are you still insisting that the committee consider removing or redrafting or deleting those provisions in addition to that exception that you have advanced?
Right.
Just, again, want to get some clarification.
Thank you, Member. In answering that, as long as there's a public interest exception in the Act, we are not advocating for removal of those clauses whatsoever. Those are still wrongs that we recognize, that have been recognized for decades, and they should be legislated into law. But what they should not be legislated into law is absolutely no protections for people's human rights and constitutional rights. And even any act, any modeling that one uses to come up with the draft law, there are always protections built in that specifically mention human rights and press freedoms. And those apparently have been stripped of this act. I note that this committee has expert assistance from Zahid Jamil, a Pakistani-based barrister. I understand you all have a report written by Zahid himself. And in that report, he goes through great pains to indicate that all of the HIPCOR models, the Commonwealth models, they all suffer from major defects in terms of the balancing act that is important and the lack of protection for human rights and free speech.
Okay, thank you, Mr. Chair.
Dr. Crown? Are there other laws? Because the issues that you're raising is not novel, it's one that democratic societies would have been grappling with for quite some time and continue to grapple with. Are there any other laws from your expansive and extensive research that has a formulation along the lines as you have just proposed that you could direct us to?
Thank you, Member. So just to be clear, are you asking in relation to cybercrime?
Yes.
So in relation to cybercrime, the model, the convention, the Budapest Convention, that does in fact, it's Article 15, I can direct you to it, Article 15.1, Article 15.2, Article 15.3, they all deal with safeguards and protections. And those articles, even the committee's own expert, Mr. Jamil, acknowledges that the HIPCAR model and then the Commonwealth model all stripped out Article 15 from it. So in terms of where to turn to, you turn to the most authoritative text in the world on cybercrime law, which is in fact the convention.
Yes, but I'm talking about specific national laws reflecting the terms of the convention. Could you direct us to any specific laws where that is a feature?
Yes, so any of the 57 signatories to that convention in their domestic laws, they would all have to have exemptions that protect human rights. So every country in Europe, Australia, Canada, the US, Dominican Republic.
Yeah.
So any one of those that have adopted that convention, which they all have.
If I could just assist Dr. Crown to my colleague, the difference is the monistic and dualistic approaches in the European context in particular. Signatory and ratification of convention incorporates into domestic law. In the Commonwealth, there's been an exception and a collision of the rules, in particular in the United Kingdom, where the UK law stands at odds with the European Convention rules, as has happened in data protection, and in particular in DNA and other laws. So there is a distinction between some aspects of the Commonwealth and the European position. Dr. Crown, forgive me for interrupting, but I'm really intrigued to understand, so that we're comparing apples with apples. Do you have any views on the regulation? So we know that there are other articulating laws which would very usefully assist this purpose. One, the Data Protection Act. 2, whistleblowing legislation. 3, this particular piece of law, which would be, if this public interest exception is accepted, it would be a remarkable improvement over the Computer Misuse Act, which is in heavy collision with everything that we're discussing here, and which is the existing law. But in the apples versus apples comparative context, do you have views on regulation per se of the media, codes and conduct, voluntary versus mandatory prescriptions, that sort of formula?
Thank you, Mr. Chair. So I guess if there's one thing we do agree on today is the Computer Misuse Act.
I think we agree on a lot more, Dr. Crown.
I'm not so sure.
I don't know where you're running away with that impression.
But in terms of why MATT is here today, media regulation, quite frankly, I would respectfully submit is beyond the ambit of why we're here today.
I accept that, but I'm asking insofar as you're an industry expert and your submissions are here, and you're recommending the Budapest model, and we're looking at European versus some of the Commonwealth comparators. In comparing apples with apples, I'm just asking whether you've come across a regulatory environment in those jurisdictions which articulate alongside with legislation of this type.
Well, so in any of those jurisdictions, there are in fact complementary data protection laws, and most of them, not all.
No, specifically on the media end, voluntary versus mandatory regulatory environment for journalism.
Right, okay, well, Mr. Chair, again, in that context, you're asking about media regulation, and what we are here today to discuss is the criminalizing of what is in effect journalism or academic research and so on. So, Mr. Chair, again, with respect, that's a little bit of a red herring, as much as I love herring, but it is a little bit of a red herring in that respect.
Let me explain it for the benefit of the listening public. When we consider anti-terrorism laws pop up, but the substrata matrix doesn't allow for apple versus apple comparison, because our rules of evidence, our sequestration rules, etc., just don't match up. So what I'm asking is, if we're recommending the Budapest Convention, the epitome of human rights protection, 57 countries have signed on, gold standard, Articles 15, etc., onward. What I'm asking is, can you assist us in comparing whether there is a regulatory environment of any type? Because I don't know. I will go and look myself. But you surely must have come across it in looking at the Budapest model as the preferred model, which in fact criticizes the HIPCA models, etc. Have you come across other articulating limbs in a regulatory sense for the media itself?
So, Mr. Chair, so if you're asking if there are regulatory bodies in any of its jurisdictions that also treat with the media, then yes, then there are in fact bodies that treat with the media. But all of those jurisdictions, one thing they prize is in fact the freedom of the press. So it's not regulating the media in the sense of censoring the media. No, but I need to be very clear too as to what Matt's position is. The regulatory environment does not speak to a censoring environment.
No, it doesn't, but it assists insofar as voluntary or mandatory sanctions may apply from regulation. Regularization also includes identification. So we'll go off and have a look at that. And just for the record, this committee and Trinidad and Tobago, which I know you're well aware of, also prizes the freedom of the press because it's in our constitution and it's the supreme law of the land. So again, we agree on more than just the submission that you say we agree upon. So we'll have a look to see what the regulatory positions look like on that end. If you are able to assist us in just pointing us to reference examples, voluntary or compulsory regulatory points, we'd be very grateful if you could.
I'll be happy to, Mr.
Member Padara.
Thank you, Chair. Good morning, all. Dr. Crown, with respect to the public interest test that you directed us to with the Canadian Supreme Court, the question really lies in looking at this particular model with respect to the public interest test. You also alluded that, of course, legislation doesn't only stand alone, that you must also look at the case law that exists. In advancing that public interest test under this Canadian Supreme Court, I'm wondering, did you look at R versus Anthony Cook and R versus St. Cloud in putting forward this determination? And if so, what are your thoughts with respect to the outcomes and the implications those particular cases had with respect to the public interest test?
Thank you, Member. In relation to the test we put forward, the test was primarily a response to the chair had asked the first meeting of MATT as to their views on the Reynolds factors. So what we looked at was the public interest in that sphere, in the sphere of defamation law, not public interest as it may have been interpreted under criminal law or even privacy law or copyright or any other sphere, quite frankly.
Chair, if you may. Respectfully, sir, I would like to suggest that you take a look at those two particular cases, because if we are being directed to the public interest case under the Canadian Supreme Court, those two particular cases...
Mind you, that applied in defamation, huh?
Correct, yes. But with respect to the implications it will have on the other ambits...
What Senator Hines was asking in a pointed way, but he didn't drill it a little bit further, was whether there are common law jurisdiction examples in the criminal law of an exemption of this type. There are certainly civil law examples of that. And the idea is a very intriguing idea, this exemption. It forms a nice balancing act. So I think the question is, if you'd permit me, Dr. Crown, are you aware of any common law jurisdictions that have a statutory criminal law exemption of the type proposed by MATT?
Yes. Thank you, Mr. Chair, for, I guess, clarifying what I didn't understand. If one looks at BVI, so BVI's cybercrime law, they, in fact, had to amend their cybercrime bill to specifically take into account the public interest. And the media in that jurisdiction were particularly keen on seeing that. And so they did, in fact, amend their law to include a public interest exemption.
Fantastic. Thank you very much.
No problem.
Member Richards.
Thank you, Chair. Through you. Good morning, colleagues. Oh, but maybe good afternoon. Just let me state my interests one time, as Dr. Rampazad indicated earlier on. and Member Mark, one of the issues that I've had is the positions I sit on. To follow Dr. Crown's references, I'm an academic and researcher, a media practitioner, a public official, and a committee member. So, all in one. So my interests kind of span the gamut of much of the discussions, many of the discussions here today. I appreciate and I'm a lot more comforted by the MATT's, through Dr. Crown's fulminations, the expansion of what the committee has to consider as the gamut of journalistic practice. Because I was getting the impression that it wasn't as clear as it should be. And I think Dr. Crown's contribution on paper and earlier this morning added a lot for consideration in terms of what has evolved in the journalistic practice and the many areas that we may not have been considering in terms of this. I'm not a legally trained man. There's a lot of exchange between the Honorable AG, the Chair, and Dr. Crown, who are extremely experienced and legally trained minds. Just for my own understanding, is the new concept inclusive of the public interest and responsibility limbs that you discussed now to exclude the possible criminalization of journalistic practice? And I like the fact that Dr. Crown included academics, calypsonians, independent media practitioners, NGOs, persons who are social and political advocates in some instances, in terms of our consideration. But does this now exclude that possible total criminalization and now put the element of criminality on a particular act by someone who may have not met these two limbs as you've put them, the public interest aspect and the responsibility aspect?
Thank you, Member. I mean, in relation to that, if quite frankly you do not satisfy the limbs of the test, then in our view you have committed a cybercrime.
Right, and we've spoken quite a bit about the media's protections. I fully agree with that, being a practitioner myself, because as Dr. Ramprasad indicated, I'd hate to end up participating in passing a law that incarcerates myself down the road, because it could possibly happen. And from the public privacy interest aspect of it now, is it the perspective of this public interest and responsibility aspect now? And I'm just going to draw a scenario here. Media practitioners get information from all types of sources. They may not necessarily know if the source has accessed this information in an authorized manner, in a legal manner. And if it is now that that information is passed on to a media house or published or broadcast and is passed on to a media house and does not meet these benchmarks of public interest and or responsibility, is it now then the perspective of MATT that the media house or practitioner will be covered, or is it that the case will go to a judge, a court, as the AG suggested, possibly through the DPP, and that person who passed on, because the information and media people protect their sources. It is part of what is sacrosanct about media practice. Where's the public redress in this? I think that's the basic question. In terms of the person who would be found responsible if it does not meet the public interest and the responsibility benchmarks, when that has been passed on by what is going to be a protected source and may not have met the benchmarks of public interest and responsibility. I don't know if my question is clear. In terms of, for example, somebody hacking into my computer, getting my information and
using it maliciously.
And maliciously unauthorized.
Well, then that will fall under the Act.
Right.
You'll be caught under the Act because it's malicious. Journalism is not about malice and mischief. Mm-hmm. Those things are addressed by the bill that is in front of you. What is not addressed and what is not protected are people who are not motivated by malice and by mischief, but by the public interest.
Mm-hmm. So you think this public interest aspect adequately covers the privacy aspect, which is to me equally as important, in terms of people's data and information.
Yeah, and I think you see
because that has been a big concern
and
from the public perspective. While we're protecting media practice rights, and we should fervently, we also have to equally look at protecting people's privacy from malicious intent in some instances. And sometimes people's idea of what is in the public interest, as Dr. Crown and others have indicated, it evolves. And where's the benchmark going to lie eventually? Is it going to be determined by a court of law?
Well, I mean, there is massive jurisprudence, and I mean, your committee perhaps knows this better than our side. There's massive jurisprudence on the public interest, and there's I mean, encyclopedic in its amount, the amount of information there is talking about the public interest. But you have touched there on, I think, for me, the intrigue about balancing privacy and disclosures in the public interest. So I'll ask Ms. Hawkins to address that, because that is something we took very, very seriously and looked at very deeply.
And let me just add one more consideration while Ms. Hawkins, I almost called her Francesca, sorry. Public interest is also very cultural, as we would all know. Different jurisdictions, or why we might want to cite case law as precedent. Cultural aspects also play a very big interest from jurisdiction to jurisdiction in terms of what may be or may not be considered in the public interest. We have a different political environment than London or New York. Our culture is different to London and New York. And how are we going to balance citing case law in those jurisdictions with what may be considered public interest, or what has passed for, well, the public has a right to know X and Y in terms of people's information in Trinidad and Tobago, versus in some other jurisdictions, there are more stringent allowances where that is concerned. And what is the MATT's perspective on that? Because that public interest aspect is extremely culturally driven too, from jurisdiction to jurisdiction. Responsibilities are a lot more clear-cut, but public interest, when you add the cultural component, can get a bit hazy.
May I just interrupt? Forgive me for answering a question put to someone else, but it's only the courts of Trinidad and Tobago that are going to interpret what public interest is, with the filtration to the Privy Council. So there be that. But as matters of fact, it'll be the High Court, then on law, the Court of Appeal, and then ultimately the Privy Council. So there is that flavor of filtration for the local context. One need only look at the Panday decision or the Ken Gordon decision in terms of quantum of damages for what is considered to be defamatory or not. So I'll just put it into that context. I take away from this submission.
If I could just say,
yes, please.
I just added the contribution based on what has happened in the past in Trinidad and Tobago and the damages that would have been meted out to people in the past,
yes,
which may not have met the benchmarks here.
I'd like to put on the record, please, it's not only journalism that is at stake. Politics is at stake. And I'm a practicing politician. It took me a long while to associate myself with that label. But I am a practicing politician. And there can be no more subject of ridicule than a politician. We stand and we take the blows, as we're expected to, putting ourselves in the public limelight. But this bill affects the practice of political aspects as well, because we don't communicate only on a platform or in Parliament. There are other methods of communication ourselves. And whistleblowers come to us, just as they come to you. In fact, they come to us with greater frequency. What I accept that we have, for those of us when Parliament is in session, we have Section 55 of the Constitution, which gives us a privilege against criminal and civil action. So I'm taking the spirit of your flavor in the Fourth Estate into that kind of submission. So I just wanted to put on the record, don't for one moment lose sight of the fact that we too, each member inside of here as practicing politicians, are subjected to this law ourselves and may find ourselves at risk. So I just wanted to put that on the record.
May I just add quickly, we signed up for that. I'm talking about members of the public who may not have signed up for public office and scrutiny and the protections that I'm asking on their behalf.
Absolutely. So that balance of right between the right of privacy of the individual or collective bunch versus the public argument.
That's right, and I think, and that applies, Member Richards, not through you, Mr. Chair, not only to public figures vis-a-vis private citizens, as it were. There are certain privacy rights that public figures also have, and that is to be remembered as well. I think I wouldn't agree with you on entirely on the cultural elements and the cultural argument, but I think where your question perhaps wants to go is that public interest is not the definition of public interest. In fact, it's a difficult term to define. But part of that definition is certainly not that public interest is what interests the public, because the public could be interested in a lot more than can qualify as the public interest. But I want to give Ms. Hawkins an opportunity because I think we do have some information that will help to clarify some of those boundaries.
Yeah. Dr. Crown.
I was just about to...
Oh, sorry. Huh? Oh, Ms. Hawkins was about.
Thank you.
I'm sorry about that. Feel free.
Good afternoon, everyone. Mr. Richards raised some questions and concerns about privacy. And as Dr. Rampasad said, this question of privacy and the balance between privacy and the public interest are concepts that we have looked at. And just to clarify some of our thoughts on privacy as it affects our solution through a public interest exemption. Just to be clear, the term public interest is not the same, as Dr. Rampasad said, as what may be of interest to the public, i.e. that which gratifies curiosity or merely provides entertainment or amusement. We respectfully recommend that consideration of a broad, non-exhaustive list of concepts that go to the meaning of public interest could go into the object section or the preamble of the Cybercrime Act. And this comes to Mr. Richards. Internationally, public interest law is a growing mechanism through which free expression and press freedom are differentiated from criminal cyber activity and serious breaches, digital breaches of privacy. In its current form, the bill makes no such distinction between the public interest and privacy. Given that privacy is fact and context specific, it is appropriate to keep concepts such as the public interest broad and flexible enough to respond to the facts and circumstances of any particular case. Public interest concepts include, but are not limited to, freedom of expression, freedom of the media to investigate, comment, and inform, open justice, privacy, public health and safety, the proper administration of government, the prevention and detection of crime and fraud, the economic well-being of the country, and in some instances, national security. Well-established tests exist to determine what is in the public interest. As indicated by Dr. Crown and others, the Freedom of Information Act in Trinidad and Tobago already provides some precedent on defining the public interest and can provide some guidance on the broad meanings of public interest for inclusion into the preamble of the Cybercrime Act. In the UK, the Joint Committee on Privacy and Injunctions concluded that there should not be fixed statutory definitions of the public interest as, quote, the decision of where the public interest lies in a particular case is a matter of judgment and is best taken by the courts in privacy cases. Community expectations of privacy change over time, and it's another reason to include a non-exhaustive list of public interest matters for court to consider rather than fixed definitions of the public interest. Flexibility will allow the meaning of public interest to develop in line with changing community attitudes as well as developments in technology. Including broad concepts that go to the meaning of the public interest in the preamble of the bill, protection will be given to freedom of expression and press freedom is guaranteed in the Constitution and will resolve many issues raised by MATT and other stakeholders over the course of these sessions. Persons who work in media and journalism, trade unions, writers, commentators, photographers, artists, composers, calypso singers, humorists, researchers, and civic organizations concerned with disclosure and transparency would continue their work in the public interest with comfort, without self-censorship, fear of arrest, or criminalization. So I hope that you can see that there is a large body of existing work that has been done to differentiate privacy, serious breaches of privacy, especially in the digital sphere, which is something that we want to be very concerned about, and the public interest, the differentiations
Thank you very much. Member Ramkisoon.
Thank you, Mr. Chair. Somehow I always get borrowed time. Thank you. To you, Mr. Chair, just a quick question to maybe Dr. Crown. From your submission from May 26th, if you look at Clause 12, Clause 5, 7, 11, they would probably be dealt with your public express or public interest exception. But in the interest of Clause 18, would you believe that exception would deal with your issue raised with harm? Because you did not only raise it, but it was also raised by the Center for the Law and Democracy from the letter dated the 1st of June. So we did not get any time on Clause 18, but because of the time constraints we have today, because today we do have Senate sitting in a little bit, I don't know if you thought it was addressed already, which is the issues to deal with Clause 18, which the
Serious
definition of,
emotional harm.
yes, harm.
Right, thank you. Thank you, member. So in relation to Clause 18, so in the opinion, Clause 18, the exemption we propose could apply to Clause 18, but Clause 18 is a bit unique because it's intended to cover non-computed data offenses then, right? It's intended to cover things like cyber harassment, cyberbullying. So we propose that Clause 18 could include a bad faith element. And the bad faith element, it still criminalizes cyberbullying and cyber harassment because that could never be done in good faith. But it also ensures that journalism, if it's done responsibly, again, by definition, it cannot be in bad faith, that is protected. And it also addresses some of the other groups' concerns about ensuring that parody and satire are also protected. Because again, a true parody, a true satire, the dominant motive of it is not bad faith by definition of both of those terms.
Thank you very much.
Sorry, and also, Member Ramkisoon, the question would be whether the harm and public interest on a scale, whether harm outweighs the public interest in a particular instance.
And in the subjectivity and objectivity mix that the clause actually provides. And we've borrowed from New Zealand in that reflection. Members of MATT, may I thank you profusely for your submissions. Dr. Crown in particular, forgive me for singling you out. Your submissions have been very, very, very helpful. We thank you for pouring your effort out and very importantly for providing us with some of the source material behind your submission, which this committee will no doubt benefit from. Again, we are open to any further submissions that you wish to present, any clarifications after today's event has settled upon your minds that you think needs to be put forward. The committee certainly welcomes anything further that you may have. I don't know if you wish to say anything in your close or wrap up. We technically still have UTT in the room and a sitting of the Parliament ahead of us.
Thank you, Chair, and through you, members of the committee, we thank you very much for allowing us the opportunity to appear a second time. And we appreciate also your invitation to make further submissions should anything occur to us further. And we thank you for the dialogue and the opportunity to dialogue with you and with the public on a matter that is really quite critical. Thank you.
May I say this? In the 5 years that we've been discussing cybercrime as a country across two governments, it's the first time we've had a joint select committee and the first time we've received council submissions from MATT. I think we've made a very important step today as a nation, and I want to thank the stakeholders for treating with the engagement of this issue in the fashion that they have. It is certainly something that can redound to the benefit of Trinidad and Tobago, and perhaps cut the path to leading the way. So again, thank you, members. We'll do a short suspension and ask UTT to do a little musical chairs with you.
We can't stop. We have to go in, right?
So we're going to go straight in. Good afternoon again, members of the public, and welcome back to the Cybercrime Committee as we go live from the Parliament, again on our Parliament Channel 11, on the radio frequency 105.5 FM, and on the ParlView YouTube feed, and again by way of repeat. We return to the public inquiry into the Cybercrime Bill 2017, and we are inviting the representative of the University of Trinidad and Tobago, UTT, Dr. Wu, to this committee. For the record, Dr. Wu, would you please introduce yourself?
Speaker, okay. Thank you. Thank you, Mr. Chairman. Thank you, committee members. My background is computer engineering. I have a PhD in computer engineering in cybersecurity from McGill University in Canada. I also have a business background. I used to work for a Hong Kong investment banking firm, in Wall Street investment banking firm, 6 years. So today I'm going to talk from a business point of view and a research point of view. So this bill, some clauses may have some problems. You know, Trinidad and Tobago, right, is probably best locations to build cyber security business and research in the whole Caribbean. Some wordings and some clauses in these bills may kill the opportunities to build the business and research. So also, the problem for security research is that accessing computer network is the very definition of their job. So for example, me, I access computer network. I intercept the data every day, you know. Sometimes I go to a movie town, you know, it's the Starbucks. I can intercept people's, you know, wireless traffic. So these bills would cheer security research, and harm the TT's cybersecurity industries. I would say some wordings in the bill were problematic because it creates new liabilities for security researchers and businesses who identify and disclose the weaknesses to improve cybersecurity. So basically, it has a potential to effectively outlaw the majority of cybersecurity research in Trinidad and Tobago. So after that, you know, if this law passed as it is, the only people looking for vulnerabilities in the Trinidad and Tobago are basically criminals and spies. You know, that's right. So a few wordings and clauses especially harm the research and the cyber business. For example, the clause for illegal devices, clause 11, illegal devices. So these illegal devices, so we need exceptions or safeguards. For example, the devices I use probably every day, try to reverse engineering or use software to do analysis of the cyber traffics. So this could get me into jail. And most of the softwares and like operating system, for example, Windows, have built-in those toolkits, to capture like traffic data. So this is one clause is probably going to do harms. Second clause is clause 8. Clause 8. This clause 8 is illegal interceptions of data, illegal capture of data. Capture network data is very job of cybersecurity professionals. Right. So this clause 8 prevent researchers and the businesses use tools such as Wireshark, TCP dump, that are designed primarily to intercept and capture network data. But these serve dual purpose that can be abused by malicious actors. So basically, the good people, bad people use the same tools. Right? So this law should not ban them in a blank manner, but instead regulate only their malicious users, malicious use. So this is a second clause. We feel like may have some problems. The third is illegal remainings. Illegal remainings. Now I find out that these illegal remainings without carve-outs, exceptions or safeguards. For example, if you are allowed to access a computer system 5 minutes, if you forget, log out. You violate this clause. Right? You probably end up in jail. So, and the second issues for this clause is illegal remainings is basically an extension of illegal access, right? And it should be treated as such, as opposed to a separate offense. Right? The separating of those two, illegal remainings and illegal access, as is the current bill, would result in separate counts. Each time there is illegal remainings, which also entails illegal access. So how you define illegal remaining, right? So I'm in the system for 1 second or 10 seconds, For example, sometimes I have to go to the some ISIS website because I'm the founding director of Caribbean Institute of Cybersecurity and Cybercrime. That is the only one in the whole Caribbean. We are started operating right now, offer master courses, master programs, and do researches. And U.S. government support us. So we have to, make sure this has certain clarifications properly defined right, in the bills. And the most important wordings which could do harms is called access, or illegal access, or authorized access. Right? Because the information security professionals who rely on gaining unauthorized access are concerned that it will enable prosecutors, corporations, to pick and choose whom they want to target with this new bill, and placing researchers and business owners under the constant threat of prosecutions. So how are you going to define access? How are you going to define the authorizations? Who authorizes you, right? So that is important, So So if this bill passes as it is, the only people who will be prosecuted will be those who try to report vulnerabilities for the public interest. Right? And the criminal hackers who are actually stealing data and taking it to the dark web will still do that. Right? So you actually prevent the good people, right, doing for the public interest. Yeah. So I find out in the state of Georgia of the United States for the wording in the unauthorized access. So this wording, unauthorized access laws in the 47 states in the US have additional carve-outs and protections for independent security research and white hat hackers, gray hat hackers. Both California and North Carolina, for example, right, require proof that unauthorized access or the gain to devise or execute a scheme or artifice to defraud, deceive, or extort to prove guilty. Otherwise, there is probably no Silicon Valley in California anymore. People just move out, probably move to Singapore. Meanwhile, state of Alabama avoids broad language by outlining 8 specific cases that constitute access without authority as a crime. So you see, so that is very important because this wording is extremely undefined. Right? What do you mean by access? Unauthorized access, who authorized you? So that is very, very important. You see. So,
Dr. Wu, sorry to interrupt you.
Yeah.
Your submissions are wider than the comments which you have submitted, but they are extremely useful.
You see, to be honest, sorry about this. I interrupted you. Sorry. This comments submit. Actually, I didn't submit it. I don't know who submitted it. so I have to say, I take this opportunity to withdraw these comments.
Thank you,
these
sir.
comments basically is not that deep.
I was just about to draw the distinction between the written comments and the very in-depth and very useful analysis that you're giving now. And so you've taken the words out of my mouth. One, that you clarify the written submissions, which are different. So those are withdrawn.
Right.
Secondly, can we ask that you actually provide us with your submissions?
Okay.
Because your submissions go into a very different environment, which is equally important for the committee, which is the commercial exploitation industry, which is lawful against unlawful activity of cyber criminality,
right,
including dark web operations.
Right.
In fact, I think that our committee needs to hear a lot more from the UTT and from you, because you have a very unique skill and experience that we have not had an address upon. So may I invite you, please, in fact, what we would like to do, Dr. Wu, is it possible that we can ask you to submit a more fulsome written submission, and then we would like to invite you to come back?
Okay.
We actually propose that this committee meet on another date shortly. We're thinking about this Friday. We're also thinking of days next week.
Okay.
Whichever of those may be convenient to you, I think it would be useful so that we can digest your submissions, that we see it in a bit more detail, and that we then, now it doesn't need to be pretty, let me put it to you that way, simple bullet points of what you're looking at. We are not looking for legal submissions only. Business reality is equally important, especially from an industry expert such as yourself. Are you comfortable with this suggestion?
Yes, thank you for giving me opportunity to submit.
It then meets very neatly with the fact that we have to sit in Parliament in a short while, so that we've technically run out of time.
Yeah, I understand.
But I want to let you know that I'm not cutting you off.
No, I know, I understand.
I'm inviting you for further submission. Okay, is that acceptable to you, sir?
Yes, thank you for having me.
Thank you, Dr. Wu. Sincerely appreciated on behalf of all of the members, and therefore we look forward to your attendance for us to ask you the questions after we've considered the more detailed submissions.
Okay.
Okay,
So
because there would be some submissions that we'd ask you to consider as well, because there are certain legal aspects that can perhaps answer some of the considerations you make, and we'd like to put it to you to get your clarity of thought.
Yes, okay.
Okay,
Thank you.
members, is this agreeable to all?
Yeah.
Yes?
Yeah.
Then thank you so much, Dr.
Thank
Wu.
you, Mr. Chairman. Thank
May
you.
I,
committee
may I
members.
then officially bring this committee's public aspect of inquiry to a close this afternoon as we properly sit, and we will certainly be back into the public domain very, very shortly with a further submission. Thank you so
Okay,
much, sir.
thank you.
So
And
we're,
whom I
so we're
should submit
adjourned.
to?
Thank you very much.